Good afternoon. Thank you. All right, let's go ahead and get started because I know you all have very, very busy study schedules. Now, those of you in the back, please make sure that you can hear me. If you can't, technology, so you can't hear. Okay, this mic is connected to the recorder. It's not blasting out to you there. This mic, is this picking me up, you guys in the back? Yes, all right. Hang on. Okay, technology is great when it works. I'll use this thing and that thing. So we're going to begin a series of classes, usually on Friday, but not always, and we're trying very hard to work with the schedule that you have for the commercial courses, which is not always easy, but we're trying very hard to make sure that we're not conflicting with anything else you're doing. Today's class will focus primarily on the MBE portion of the exam, but I am going to give you some preliminary thoughts about what I think is going to be tested in Florida, and I'm going to talk a little bit about Florida essay writing because I know a lot of you have an essay that's assigned for next week. So I want to give you a few little hints before you do that. But first, the first part of the class, we're going to do MBE. Today's class will probably last maybe 2 hours, maybe a little bit more than that. Classes going forward will probably last more than that. But I am very, very conscious of your time, and so I don't want to abuse your time. You have a packet today in addition to the questions that we're going to do. You have the lunch request. Please fill it out and leave it up in front or pass it forward or something. We will provide you with lunch on Tuesday and Wednesday. A good thing for several reasons. You don't want to have to worry about going out into downtown Tampa during the exam and finding a place to eat. It's a hassle, and you might not get done in time, which could be really crazy. So right there at the convention center, can't tell you what room yet because they don't know. But Mercedes and her crew from Career Services will be there to provide you with a lunch. And we have picked out a menu of bar-safe foods, if you will. And it's a wide variety. We have different kinds of choices, including a vegetarian choice. But the idea is we're trying to give you food that's good for your brain and that will sustain you in the afternoon without putting you to sleep. So please fill out the form, and also you'll know as you're going through your commercial courses, and probably many of you know already, you cannot take anything into the exam. I mean, they search you with metal detectors and everything else. You may have some things that you bring to the convention center. Usually we have a table, again, that's staffed by Career Services, and you can kind of leave your stuff underneath. I wouldn't recommend bringing tons of stuff, but know that that's there for you. We'll also be providing you with earplugs, bar-safe earplugs, a little bit later in the process as well. Now, before we jump into the materials, just a couple of other things. Very important, get your raffle ticket in. Because each week we will draw one person, somebody, and we need it to be somebody who's taking the exam in July. If there's anybody out there who's waiting until February to take the exam, we'll get you the next time around. But one person will get drawn, which we'll do a little bit later in the session, for one free hotel night, up to $300, is it now?
Yes.
Up to $300. So you can't take the presidential suite, or you can, but we won't pay for it. And each week we'll be doing a drawing. When we have the barbecue that Peter Kelly will be putting on for you a little bit later in June, we'll draw for 2 hotel rooms. In addition, yes, ma'am?
I'm sorry, in the hotel room, if you win it, the folio has to have your name. It can't be your roommates that he paid for it, and then you're going to give him half because you won it. It has to have your name. Okay? So
Okay.
if you're making your reservations, make sure it's...
Right. We
What if I win it and I give it to the person whose name my hotel room is under? I can't do that?
This, Isn't your name also, can't you, isn't your name be under it also? I don't know. I
Okay.
know the budget is very
Okay,
complicated.
yeah. I'm not going to, yeah, we'll talk about that individually if it arises. But please understand that all of this has to go through our accounting department, and that's why we have to have specific rules on it. You know, we're not just handing out checks. It's a little more complicated than that. Sarah already mentioned to you the released questions from the National Conference of Bar Examiners. You may have already had access to them. If you have not, we are subsidizing your purchase, and I would highly recommend that you get a couple sets from the National Conference of Bar Examiners. They are real released questions. They're actual bar exam questions that have been released, and they are recent questions, so they should still be valid. And it's very important to practice with actual questions. All right, before we jump into today's substance, any kind of questions, comments, anything anyone wants to get out on the table? Yes, sir.
What do we do with the
Raffle
raffle ticket?
ticket. Curleen or Sarah, can you walk it around? Okay. Yeah. Okay. Other questions? All right. As I mentioned, we're going to start with. Okay. Thank you all very much. And even if I have a microphone, you kind of have to keep the chatter down, or your classmates won't hear. And we have a lot of people in the room, which is terrific. But let's keep the pace moving, which means we have to keep the chatter down. We're going to start with a session on MBE questions. Now, I know you've been doing a lot of MBE questions already. But the reason I start with this session is that's where you're at in your bar prep class at this point in time. You really haven't done anything with Florida. So it doesn't make as much sense to jump right into Florida. The MBE, of course, is half the exam. How many of you took ALS? I'm just kind of curious. A lot of you did. Okay, good. I know I had a lot of people ask, is this going to be the same thing as ALS? Well, not exactly. We're going to do some questions together, but we're going to do all 6 questions from all 6 topics. I'm going to talk about not only what they cover and how they like to cover it, but how they like to test the questions. So without further ado, I'm going to ask you to pull out your packet.
Excuse me.
Yeah.
The attendance sheets, where did they?
All right. All right. The attendance sheet, remember, you have to sign in. The 2 reasons why you need to sign the attendance sheet, so please do. Number 1, we want to know who you are in case we need to contact you about anything. Sometimes, for example, students will ask me a question in class, and I'll say, you know what, I need to do a little bit of research, and I will get back to you. I need to know who's been here so I can send the information out. Also, as Sarah said, for those of you who do attend the bulk of the classes, we give you a little extra gift of a Starbucks card at the end of the sessions. And please do, by the way, a number of you have already contacted me with questions about studying, with questions about substance. Please feel free. You can send me an email message. You can send it over the weekend. You can send it at night. I respond pretty quickly to your questions. And if it's substance, I'll respond with a fair amount of detail. If for some reason I don't know the answer, and I don't know everything, but I do know a lot of what's tested. But if I don't know the answer, I will find out. So that's number 1. Number 2, really important. If you are writing essays, and again, I know that you're going to write your first, many of you are going to write your first essay next week, you can send me your essays for comments too. Even if it's an essay that you've written for Barbary, if you want a second pair of eyes to look at your essay, not a bad idea. And I will turn your essays around pretty quickly. If I get totally swamped and I get 100 in a day, well, maybe I can't get 100 done. But I respond very quickly with them, and likely will respond more quickly than your commercial courses because they have so many students they have to handle. So please feel free to send me essays. As many essays as any one person sends me, I will read. I had somebody last summer who sent me 17 essays. I read and critiqued every single one of them. Wow. And that person passed It's not surprising, and passed with a really nice Florida score. So it does help to practice, but with one caveat. Now, I know you're, again, if you're in Barber, you're doing contracts for next week. Usually, that first essay that I see is pretty bad because you haven't studied the substance. For the most part, it makes more sense, doesn't it, to learn the substance first and then write the essay? So just keep that in mind as you're writing practice essays. Don't sit down this weekend and write 15 essays. It's not going to be particularly helpful for you or for me. You write the 15, I'll read them, but you won't like what I say, right? Okay, other questions before we jump into the substance. All right, you all have your clickers, right? And you all know how to use them? Yeah, pretty much everybody's used them somewhere along the line, right? All right, so what we're going to do is we're going to go through this relatively short set of questions. Again, I have a couple of questions from each of the 6 subjects kind of mixed up. And you're going to do a question, do just one at a time because the machine and the program can't recognize multiple questions at a time. So we're going to go one at a time. I'm going to give you about 2 minutes to answer a question. But don't speed along, especially this early. Take the time that you need to answer the question carefully. So let me get this started and go right ahead if I can get that going. Well, come on. Hang on a second. Go ahead and answer it, but for some reason this isn't wanting me to. There we go. All right, go right ahead. Approximately how many do we have in here?
I don't know.
Yeah, it's probably about 80, I guess.
But they have to use the attendance.
We're asking for that in the front, but I don't know.
Okay, do we have anybody out there who hasn't answered yet? All right, so let's call it and let's see what we have. Okay, pretty good. That's the right answer. Now, notice a couple of things. First of all, don't get too excited, right? I like to start with an easier question, just, so you feel good. But we had a few who didn't pick the right answer. So let's talk about what's going on here. It's a torts question, right? And some of you may have discovered already that torts seems simple, but it's not. So don't get lured into complacency with torts, particularly when you get into the area of negligence and what I'm also seeing, or at least in past exams, with products liability in general. Students really struggle with those areas. So make sure that you spend sufficient time on them. This is a torts question, and if we look at the fact pattern, it's one that I took right out of the notes in the Prosser casebook. Why did I do that? Because the drafters, the people who draft the MBE portion of the exam through the National Conference of Bar Examiners, almost all of the questions that they write are based on real cases. Why do they do that? Because if you base it on a real case and you use the holding in the case as the right answer, it makes life a lot easier. The question is a better question. So the more that you remember from your various courses about cases, in all subjects, as we'll see in a little bit, particularly when you get to con law and to criminal procedure, but in all of the subjects, the more that you recognize the cases, the easier the questions will be. Now, in this particular case, when you get down to where the call of the question is, what is the most important thing? What word? I think negligence, you bet. Why do I think negligence is the most important word? Cause of action. Think back to torts. It doesn't matter who you had for torts, right? It's all about the cause of action and the elements of the cause of action. Elements, 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 right? You know, it doesn't matter who you had for torts. All about the elements. So you've got to identify the cause of action. And then you need to make really sure that you match the cause of action in the call of the question with the correct answer choice, because one of their favorite tricks when it comes to MBE torts questions is to give you a call that says negligence and then give you an answer that's an intentional tort. Apples and oranges, right? They don't match up. And if we look at our choices, A says yes because the boy died after listening to the music. Well, he did, but what's missing? And causation. And if you read the full case, that's exactly what the court says. What do we know about negligence? You know, in fact, years and years and years from now, when you've been in practice for 30, 40 years, you're not going to remember anything much about your bar studies. Probably not going to remember very much about law school, honestly. But you will remember the elements of negligence. What are they? Duty, breach, causation, damages. Wow, yeah, exactly. So if there's no causation, there's no cause of action. So A can't be the best answer. B says, sorry, we left D out there. Yes, because the death caused, the death of the son caused her severe emotional distress. Why is that not the best answer? Yeah, it's suggesting IIED. Now, there is such a thing as negligent infliction, but there's a whole lot more that goes into negligent infliction that's not reflected in the fact pattern. Always let those facts be your guide. What are they telling you? And as you read the facts, you've got to let them talk to you. Now, how do you go about reading the facts? There are two ways to go about it. They're both legitimate. I urge you to try them both out, because I use a method that right now most of the commercial courses don't recommend, but it works for me. I start up at the top. I read the facts first, and then I try to anticipate the call of the question. Because if I've done a good job of reading the facts, I'm going to know what the call of the question is, and if I predict the call of the question, I know I'm going to get the question right. So for me, it's a really important reading exercise to go with the facts and then the call. Now, I know a lot of people recommend reading the call of the question first. It has certain advantages and certain disadvantages. If you read the call of the question first, you can zero in, and you know this question's about negligence, which helps you to eliminate facts that might lead you astray and might make you think about intentional torts. Good and bad about that. It's good because you can focus. It's bad because it causes you to screen out facts. And in these short fact patterns on the MBE portion of the exam, every single fact matters. In your law school career, some of your professors may have written exams with red herrings, with facts that were irrelevant. And honestly, in real life, hey, when a client comes into your office, the client isn't going to say, let me tell you the relevant facts. No, they just start spilling out a story, and you've got to figure out what is relevant and what isn't. So it's a very legitimate testing tool. But on the MBE portion of the exam, there are no irrelevant facts. So you need to ask yourself, what's this fact doing here? And in addition, if you read the call of the question first, understand that you read it, you read the fact pattern, and then you read the call again. It takes you just a little bit longer. So if you are a slower reader, then either you adjust your expectations, if you will, accordingly, or perhaps you start with the facts first. I like the facts first, again, because it makes me think. And this I know you talked about for those of you who took ALS. Interact with the question. Circle, underline, stop and say, what's this fact doing here? Don't just stare at it and then blindly pick an answer choice. Each fact is telling you something really important. And the more you interact with the facts, the better job you'll do of reading and the better job you'll do of answering the question. Now, we had a few people who picked C. What did they not do? Right. They did not match the answer with the call of the question, because C says intend. And, well, we don't care what they intended in this case, because it is negligence, which then leads you down to D, which is the holding in the case. Okay, any questions? Again, this is a simple question, but don't get lulled into complacency. Number 2. You can see we're at the 3-minute and 30-second mark, and we have about 80 people, at least 80 people in the classroom. Anybody else want to answer this question? Ah, see, I told you it wasn't so easy. All right, let's see how we did. Correct answer? Oh, yeah. Now, a couple of things I want to point out before we talk about the substance here. Number one, I let you take longer on the question. Do not get so hung up on timing that you rush through longer questions. And your contracts questions and your property questions tend to be longer. You notice we did the torts question fairly quickly because it was an easy question. Evidence questions are very short. They go very quickly. You need to average out 100 questions in 3 hours. But if you get too hung up, and some people say 1.8 minutes per question, hit it, move on, you will miss questions that you could otherwise get right. Now, with that in mind, of course, you have to know the law to get the question right. And my guess is that most of you really haven't mastered 2207 yet. 2207, you know, that murky bit of prose that you talk about in your contracts class. It's a murky bit of prose, it really is. But I have to tell you, you will have at least one 2207 question on the MBE, and probably more. And it's something that's tested, sorry, but it is tested in essay form in Florida more often than you might think. Ooh. So would I learn 2207? Yes. You know, as we go along, and I'm sure as your commercial courses are telling you, sometimes you have to make some choices. And I'll tell you right up front, if you don't know the rule against perpetuities now, now's not the time to learn it. Some of you should know it really well, right? But if you don't know 2207, you need to learn it. So what do we do with 2207? The first thing we have to decide is if there's an agreement. That's 2207 subpart 1. Was there an agreement here? Yeah, we had an offer and acceptance. And the acceptance had, guess what, an additional term, which was that 1-year statute of limitations. So what do we do with the additional term? We go down to 2207 subpart 2 and we figure out what we do with it. Now, at this point, we have to ask ourselves, what about the parties? Are they merchants? There are 13 merchant provisions in Article 2. And so do not, and when we get to the contracts essay, and as a hint for your contracts essay that you're writing for next week, don't start right away with merchant status. It's not necessarily relevant. It is relevant if one of those 13 provisions applies, but don't go to merchant status until you need it. What do you need to address first, by the way, in any contracts question? Governing law. It's been drilled into you millions and millions of times. I'm going to drill it into you a few more millions of times. Start that essay, whatever essay that is. I don't know which one they've assigned. Start it with your governing law. What's our governing law, of course, in this question? It is UCC. I always say Article 2 because there are 9 articles in the UCC, but UCC you're fine with. And yeah, because it involves glass jars, and glass jars are goods because they are movable. Good. You got to think about that. Yeah, at the time of identification to the contract, you bet. So it is an Article 2 question. 2207 applies. We have an agreement, offer and acceptance, and now what do we do with the additional terms? They are both merchants because they deal in goods of the kind. Look at all the steps you have to go through when you're answering this question, right? Ooh, yeah. So they are merchants, and as between merchants, what do we do with the additional term? It becomes part of the agreement unless. There are 3 unlesses, and it's or, so it's any one of the 3. The first is not applicable here, which is if the original offer was limited to its terms. They're very unlikely to test that one, but it's there. The third is one that tripped a number of you up and trips people up all the time. Because the third is unless the offeror objects when? Reasonable time, not 10 days. And that's the kind of thing that that's the kind of detail they will test. When you are learning the material, you gotta know detail, folks. 2207 says objects within a reasonable time. Where's the 10-day rule?
No, it's not.
When is the 10-day rule? No one said it correctly yet. When does it apply?
That's for the statute.
Statute of frauds, thank you, Yasmani. Yes, statute of frauds for 2201 subpart 2 for the merchant's exception to the statute of frauds. That's where the objection has to come within 10 days. And just look at how easy it is for them to get you to pick the distractor. Because you're thinking, oh, I know I saw a 10-day rule someplace. Not here. Reasonable time. There was no objection here anyway, right? And so now our third exception is if that term is a material alteration, which is what we have in this case. Now, if you look at the cases, and it all comes back to cases again. If you look at the cases that deal with 2207 and the exceptions in subpart 2 to 2207, for material alteration, they almost always break down into one of three categories. The first is what we have here, changes in the statute of limitations. The second is any kind of disclaimer of warranties. And the third is an arbitration clause, unless it's the custom of the industry. So now you know when you read the cases, if they're asking about material alteration, then you should look for one of those three, which we have in this case. And because we have a material alteration, what happens to that additional term? It falls out, right? And so we're left with what? Well, we are left with the initial terms, but did the initial terms address the statute of limitations here? No, and so we're left with the 4-year rule, which Robin, which is from the code gap filler. So remember, if your additional term falls out, then you go back to the code gap fillers, and it is 4 years under 2725. Now, by the way, do you need to know code sections for either MBE or Florida? Do you need to know the numbers? No. It's how I remember the rules. It's just how I learned Article 2. So when I start to talk about it, you're going to hear me say the rule number, because then I know I'm going to say the right rule. But when we get to evidence, because I didn't learn evidence with a rule number, I'm not going to be saying the rule number because that doesn't signify the rule to me. So the only time you need numbers, by the way, is for con law, because they may ask you about the 14th Amendment or the 13th Amendment or Article 4, Privileges and Immunities Clause. There you do need the number. Otherwise, pretty much irrelevant. So for this question then, if I can get it to come up, B is the right answer. It's timely because we're using the code gap filler 4 years because that additional term falls out because it's a material alteration. Look at your thought process, everything that you have to do when you answer the question. If you are thinking the right things as you read the fact pattern and you see that additional clause, you know you're in 2207, you immediately go through the steps for 2207, the right answer does jump right off the page. And once again, for contracts, make sure, of course, at the very beginning that you determine whether it's common law or Article 2, because for MBE purposes and for Florida purposes, they test both. Okay, any questions on this question? Yes, ma'am.
What was the first one? We were talking about the additional terms.
Okay, additional terms. The first one is what we have here, the exceptions, the 3 exceptions on material alteration. The first kind of material alteration is statute of limitations, change in the statute of limitations.
I mean the one here, like the example here, like what is that called? If the term is immaterial,
Right.
unless the offer objects within a reasonable time, and then what was that?
The first one, if the offer is limited to its initial terms, which is, it's a rare one. But once again, the offer itself was limited. Okay, any other questions? All right, number 3. Okay, we're coming up on 3 minutes. Anybody else want to ring in? And always remember with these clickers, even though they're new clickers, always remember to make sure that the on light is still on. They're an improvement over what we used to have, but we still have a ways to go. All right. Anybody else? Oh, we're still getting some. Okay, that's about right. All right. Let's see how we did. And I have to tell you, as I was watching, because I can watch the results come in, at first, most of you were getting the question wrong. So those of you who took a little bit more time with the question and waited toward the end, unless you just guessed really good, you were the ones who got the right answer. Now, a couple of comments. Number 1. You're abstaining. Abstention's not a good idea on the bar exam because you get no chance at points. If you don't know what the answer is, pick A, B, C, or D. Pick something. They do not subtract for wrong answers. They do, but there's no chance of getting a point if you pick E. You've got a 25% chance if you pick A, B, C, or D. A 0% chance if you pick E. Now, still, even with that last-minute surge, more people picked B. You went for the juicy distractor, which means you didn't read the question carefully, because I'm guessing that you probably knew the rule. Now, mind you, I know you haven't done con law yet, but I bet it's back there in your brain from your con law class. We're talking, of course, about the privileges and immunities clause of Article 4 of the Constitution, not to be confused with privileges or immunities from the 14th Amendment. And knowing the distinction between the two, sometimes the same privilege may affect both of those clauses, but yet they're very different. When we're talking about Article 4, we're saying that a state may not deny citizens of another state the privileges and immunities it affords to its own citizens. 14th Amendment privileges or immunities clause says that a state may not deny to its own citizens the privileges or immunities of national citizenship. So remember, you've got to know that kind of distinction. Here, it's a state versus a resident of another state. It is clearly an Article 4 issue. So the question you start with, of course, is what's a privilege or an immunity? Commercial fishing license? Yeah, it could be, right? And this particular question is a blend of several cases, but all you have to do is talk about the attorney case and the fact that an attorney's license in one state can't be denied just because the attorney lives in another state. So a commercial license, yes, it is a privilege and an immunity. But who has standing under Article 4? You have to be a citizen. Can a corporation be a citizen for Article 4? Nope. So that kind of distinction you need to be aware of as well, which means then that D is the right answer, not B. So either you forgot the rule, or very likely some of you knew that rule, but you didn't read the facts carefully enough. You've got to really pick the facts apart. Every fact matters. And just in passing, it is true that the market participant exception doesn't apply to the Fourth Amendment, but that's not the reason why Fisher doesn't win here. It's because he doesn't have standing to begin with. By the way, when it comes to constitutional law, whether it is federal constitutional law or Florida con law, which we'll be talking about later in the summer, standing is always an important issue. Those threshold questions, standing, mootness, ripeness, et cetera, they matter a lot. So always make sure that the individual gets in the door, which Fisher does not in this case. Final comment on C. It's about coming time when I should change that answer choice. Once upon a time, used to be we would teach that you never pick the privileges or immunities clause of the 14th Amendment because for forever the Supreme Court had not decided a case under that clause. But of course it did with the Sands case. And so now we know that it is a relevant provision in the Constitution. Remember that the Sands case involved the right to travel. And I just want to plant that particular right in your brain. They tend to write questions, again, based on real cases and hot issues. And the right to travel is something that the Supreme Court has been thinking a lot about over a period of time. So look out for the right to travel and residency requirements because they can trigger equal protection. They can trigger privileges or immunities of the 14th Amendment. They can trigger Article 4 of privileges and immunities. Jaquetta, you had a question?
Yes, ma'am. So the right to travel and the right to earn a livelihood, that's under the 14th.
Well, the right to travel can come up in so many different contexts because it could possibly come up in the context even of Article 4, privileges and immunities as well. In other words, the privilege of you can't deny to the citizen of another state the right to travel, right? Right, travel through the state, exactly right. Other questions on this question? And please remember also, when you are reviewing the materials for constitutional law, and I want to not even urge you, I want to beg you to read those outlines. I know it's boring, but you get the substance and you get it in an organized fashion when you read the outlines. If you just do cases, you're going to have really spotty learning, and it won't be organized. As you read those outlines in con law, focus on the case capsules. The more cases you recognize, the more con law questions you'll get right. Why? Because they must draft con law questions based on real cases, because it's the Supreme Court. And the Supreme Court might like to tell you otherwise, but they can decide a case any way they want. Who's going to tell them no? They're the Supreme Court, right? So how the Supreme Court answers the question in a particular case, that has to be the right answer. They can't guess what the Supreme Court's going to do. So real cases have to be the basis. Okay, any other questions about number 3? All right, number 4. Okay, coming up on 3 minutes. Anybody else? I'm impressed. Now, a number of you didn't pick D, but still, usually in this question, I get a lot fewer people picking D, so that's good. You guys did well on this question. It's the dreaded property, right? Everybody hates, well, most everybody hates property. And I will tell you that we are not going to talk any estates and future interests today. Unless somebody wants to hang around after class, happy to do it. But we're not going to have any questions today dealing with estates and future interests. However, things like adverse possession, you know you have to know them. And they're not hard. You just have to remember the rules. Adverse possession is a very frequent flyer on both the MBE and Florida. This last exam, Florida exam, the property question had easements, it had adverse possession, it had a bunch of concepts that you should be familiar with. Just because they tested adverse possession this last time doesn't mean they won't do it again. So make sure that you can handle adverse possession. And I made this question really easy if you read the statute. You should know the rule even if you didn't read the statute, because the rule in the statute is the rule. But the point is, in property, oftentimes they will give you a statute. If they give you a statute, you have to read it and apply it. And this statute says that the disability has to be in existence when? At the time that the adverse possessor enters, which is the common law rule anyway. Was the disability in effect when the adverse possessor entered in this question? Nope. And so the answer becomes D, because possessor entered in year 1, it's year 8 now, and sorry, we have a 7-year statute of limitations. Is there any tolling ever if the disability arises after the adverse possessor enters? The answer is no, period, end of story. The only time the statute tolls is if the disability is in place right at the beginning. Okay, but again, I'm actually very pleased with the results on this question. And also, by the way, it's a question that many of us, I know Professor Zeiner also does it. I do this question in class in property, and Professor Zeiner does it in class. We do questions like this in class because we know it's stuff they test on the bar. So if you can think back to what you learned in your first year so you don't have to relearn everything, puts you a step ahead. Okay, any questions on number 4? Number 5. Okay, coming up on 2 minutes. Anybody else? Yep, pretty much everybody already. Anybody else? Okay, another good outing. This is good. You guys are doing very well. Notice a couple of things, first of all. It is an easy question. Not to say that you didn't do well, but it is an easy question. Also, it's short. Remember, I told you, evidence questions are short. Remember, when you hit a long one, like the property one you just had, instead of rushing past it, spend a little bit of extra time. Because many of you at least, when you got to the bottom of that question, finally you realized it's exactly what you learned in your property class, and it became an easy question. Sometimes the longer questions are the easiest ones because they know you're not going to read them. You follow a long question with a short question. It evens out, so don't rush through those longer questions. Now, This question, of course, is an evidence question, and a lot of people struggle with evidence. Even though this is an easy question, they struggle. One of the questions people ask all the time, people say, I just don't get character evidence, right? How many of you are thinking that? I don't get character evidence. Well, you're taking the wrong approach. So what I'm going to ask you to try to do as you study evidence, and particularly as you do evidence questions, take the following 3-step approach to the questions. It's a technique, I don't know if any of your evidence professors teach it. It's one that I learned a while back, and it really works when it comes to MBE style questions. The first thing you have to do is ask yourself, what kind of evidence is it? Is it real evidence? Is it, the murder weapon? Is it documentary evidence, the contents of this contract? Or is it testimonial evidence? Identify what it is. Usually, that's pretty easy. And then you may need to think a little bit about chain of custody, particularly if it's real evidence, a few preliminary questions. Usually, again, pretty easy. Then you come to the hard part. But if you get this second part right, you will get the right answer to the question. And you ask yourself, what is the evidence being offered for? That's the key to evidence. What's it being offered for? Now, when you ask what it's being offered for, please do not assume it's hearsay. Hearsay is usually the wrong answer, which you may be discovering already. And why is it the wrong answer? If we have any of you out there who have clerked for a trial firm or have done any kind of trial work through clinic, then you know. If you're a good trial attorney, if you can't get the evidence in one way, you get it in another, right? That's the game you play as a trial attorney. And so you should not assume that the evidence that you're being presented in a question is hearsay. That's the last thing you think about. Think about everything else it could be. Is it, for example, being offered to impeach? Maybe it's being offered to prove an element of the cause of action. Is it being offered to show ownership or control? There are all those other issues that are non-hearsay issues. And you always think about them first. And as you ask yourself about what the evidence is being offered for, think in detail. Is it a criminal trial? Is it a civil trial? Because when it comes to character evidence, big difference, right? Who's offering the evidence? Is it the plaintiff or the defendant if it's civil, or prosecution or defense if it's criminal? And is it being offered on direct or on cross? Go through all of those steps. And if you ask yourself all of those questions and kind of check them off as you're reading the fact pattern, usually you're going to lead yourself to the right rule. So instead of trying to deal with this big mess of character evidence or hearsay or whatever it is, go through those steps, because then your third step is the evidence admissible or is it inadmissible? You've already answered it if you correctly analyzed that second step. What's that evidence being offered for? Think about it, try it, and you're going to find, I think, that it's going to help you a lot with evidence questions. Any questions on this one? Again, a pretty simple question. Robin.
Well, the fact that it says every stop sign doesn't make, because I remember on the habitual rule, it has to be often, but at the same time it's got to be specific, right?
Yeah.
So the fact that it says always may support you stop at every stop sign,
Yeah.
to me that was like, well, it's more being offered as a character evidence than habitual.
Always at every stop sign, that's his
The fact
habit,
that it
right?
says every stop sign instead of saying that specific stop sign.
Well, that one and every other one, right? That's not character, that's habit, right? And I understand what you're saying.
Right. Okay.
And I do understand what you're saying, but if it says every, it includes this one, right?
I know it includes it, but that's exactly what I'm trying to. Well,
How do you differentiate?
that's the way.
Yeah.
That's the way I think it was taught. Like every.
It-
My friends told me every time you see always every, it's a red flag. So that's why.
Oh, no, I wouldn't necessarily agree with that. And I understand exactly what you're saying. It's got to be specific to this instance, but that's what's happening in this question. Okay, other questions about this question. Number 6. Yeah.
And
Okay.
then
Yeah.
here, and then you can leave it there, and then the guy can pick it up. So we're leaving now.
Yeah. This weekend. Okay, let's see how we did on this one. It's another torts question, and you guys did very well on it. Now, again, I don't want you to think that all torts questions are really easy. But this particular one should be at least in the answer choices, because our call of our question is negligence, right? So we're looking for negligent conduct. What would the reasonable driver do? Well, if you look at A, and it goes back to the absolute, sometimes the absolute is the right answer because, for example, in civil procedure, a complaint always must include a prayer for relief. Okay, you need absolutes there. But when it comes to negligence, that always is problematic. And A, of course, I don't know why that's not working. A says always stop. You don't always stop. Sometimes it makes sense, and sometimes it doesn't. So A is not going to be the right answer. And of course, C is the opposite. Always stop, never stop. They're both too extreme. Now, what D does, and nobody picked D, so that's good, but I want you to kind of focus because I'm guessing that many of you didn't look at that layer of the question. You actually have two duties in this question, right? What's the first duty? Reasonably tie the suitcases to the top of the car. Second duty, and there's nothing in this fact pattern to suggest that they weren't reasonably tied on. But then there is a second duty that arises when the suitcases fall off. So then you've got to take care in terms of what you have allowed to fall on the road. And I kind of changed a case from Prosser to come up with this fact pattern, kind of blended it with something that happened to me when I was a kid in real life. The Prosser case, you may recall, guy was driving on a dark highway, came over a hill, hit the top of the hill, and started to go down and ran into a cow. It was a black cow. And it was there was an unlit road. He hit the cow. Yeah, so I was a little too bloody, so I changed the facts. But he kept going and left the cow in the middle of the road. Well, remember, it's after a hill. So the next guy comes over the hill and doesn't see the cow until it's too late and plows into the cow. Was the one who left the cow in the middle of the road, was he negligent? Yeah, because he had a duty to foresee that someone else might come along. What was he supposed to do? Drag the cow off? I don't know. But the court said he had a duty. Maybe put up flares. I don't know. Okay, any questions about number 6? If not, number 7. Okay, coming up on 3 minutes, anybody else? We have pretty much everyone present. All right. See how we did? Better than I thought. You guys are doing well. I have to say thumbs up. Now, let's talk about why D is the right answer here. We're talking about, of course, a requirements contract. Was there anybody who didn't get that this question was about goods, right? Shopping bags. Tried to make it as easy as possible. You can definitely move shopping bags. So we're talking about Article 2 and a requirements contract in particular. And everybody, it doesn't matter who you had for contracts, you certainly talked about requirements contracts. What you may not have talked about, and trying to show you the layers of the questions. The testers, they will presume that everybody knows basic stuff about requirements contracts. But this question is actually testing the difference between increased demands and decreased orders. 2306 specifically talks about an unreasonable demand, an increase in demand that is unreasonable. It doesn't address taking less. And that language, unreasonable demand, has been interpreted by cases to apply just to increases. So what do we do when we have a decrease?
Apply good faith.
Well, always apply good faith. That's true. Every step of every contract has to be performed in good faith. That's true. But what we also see when we have no demand at all, Jaquetta says frustration of purpose, and she's right. The cases don't discuss it in those terms, but that's what they mean. Because if there's no point in taking those shopping bags, which would be frustration of purpose, then no demand at all is okay. It's not a breach of contract. And in this case, I modeled this on a number of cases, one involving breadcrumbs, the Feld case, that maybe if anybody took sales, you probably read something like the Feld case. If you take nothing because you've shut down your business, then you have not breached the contract. If you're taking nothing because you're just trying to save money, that's a breach of contract. So once again, did I just lose this?
Yeah.
Yeah, sure did. Okay, let's try that. Okay, and it's an important kind of rule for two reasons. Again, showing you that they're going to test not that basic rule, that half rule that you might remember from your contracts class. They're going to, I'm sorry?
It's out.
It's out. I have a feeling it's the battery. So I'm going to shout as best I can for those of you in the cheap seats in the back. Okay, and as I'm talking, if you guys can't hear me, jump up and down or whatever, I think that's probably lost its battery. So, important point again, the layers of knowledge that they test. They are going to give you questions like this that push you past the basic rule. And then, once again, even though it's an Article 2 question based on the statute, case law still matters a lot. Any questions on this one? Okay, number 8, and we're moving along. We'll be done with these relatively soon. Yes, they are, but they're not for the I know what you're saying, but that's the one exception under the federal rules. They're not deemed to be advisory, even though, in practically speaking, they are.
They're not deemed to be advisory.
Yeah. Okay. See how we did on number 8. Pretty good, but not perfect. Number 8 should have been really easy if you did a good job of reading. What did I stick into number 8? Carrie? Class action. Thank you very much. If it's a class action, it's still a live controversy as long as you still have a member of the class. Makes it easy, right? Of course, you also want to remember that you still have a live action if the particular cause of action is capable of repetition yet evading review. But honestly, I just made it real simple by making it a class action. Yes, sir.
Even without the class action?
In this case, yes, I think so. Yes, I was just trying to make it real easy. Yeah. That's why I said, remember, even in the absence of a class action, if the cause is capable of repetition yet evading review, then it's live. Any questions? Yes, sir.
Besides pregnancy, or like in this case, what's another example of like repetition?
Abortion.
Well, yeah, pregnancy, and it's a good question. You're going to tend to see the cases clumping in the groups you just mentioned. When we're talking about pregnancy and abortion, that's one. And number 2, residency requirements like this for tuition or something similar to it. I'm sure there are other cases, but most of them tend to clump in that area. Any other questions about number 8? Okay. Yes, ma'am. I'm sorry.
Yeah. With the class action one, it just said that somebody had, well, if all of them are the same time requirement, how do we know if somebody's still able to?
Oh, the question is if we have a class action, and how do we know that there's still somebody left in the class? Because somebody can always be joined into the class afterward. Yeah. So it's, even though maybe the original group started out as everybody graduating the same year, which they probably aren't, you can still add someone to the class. Okay, number 9. Okay, anybody else on this question? All right, see how we did? Pretty good. Good. Now, when it comes to criminal procedure, constitutional criminal procedure, remember, it is, again, all about cases. It's the Constitution. It's the Supreme Court. They can do whatever they want. So the more cases that you recognize, the more likely you are to get the right answer. And of course, we know that the question here is, and I'm going to use the old-fashioned term even though the Supreme Court says you're not supposed to, who has standing? And who has standing to object to this particular search of the premises? Now, some of you picked B because she wasn't named in the warrant. That's a red herring, right? Because they're not searching her, they're searching the house. So she doesn't have to be named in the warrant to object if she has standing to object to the search of the house. And a number of you picked yes because she was a social guest. You knew part of the rule, but you didn't know the whole rule. And to have standing as a social guest, you have to be an overnight guest. Really simple, but see the layers again. And that's one of the reasons why I want to caution against studying solely from the convisors. Now, I have to tell you, when you get to the end in the last few weeks before the exam, the convisors are gold, for those of you who are studying from Barbary. But they don't include a lot of information. And if you use them as your sole study tool early on, you're going to end up missing questions like this because you get just half rules. And you can see already, as I'm trying to show you, the examiners are going to dig a little more deeply, and they're going to go to the end of the rule, not the beginning of the rule. Yes, sir.
She did have, the guest did have standing. Why, if the guest did have standing, would the evidence be suppressed then? Why would that matter?
Well, she has.
What was wrong with the warrant at all?
Oh yeah, no. It's just because the warrant was fine, but she doesn't have standing, and that's the key to the question.
She's trying to exclude the evidence.
She's trying to exclude the evidence. She doesn't have standing to do that.
But if she did have.
Oh, she did. Then she could. Yeah.
Why, how?
I mean, I'm sorry. Wait, if because the warrant was good. Yeah, but she can't object to it anyway.
But even if she did have standing.
Yeah, right. Yeah, she would still lose. But that's not what the question's about, right? Okay, the question's about standing. I'm sorry. Yeah. Okay. Any other questions on number 9? Okay, number 10. And there are just 12 questions, so we're almost done with these questions. Number 10. Coming up on 3 minutes, anybody else on this question? Another dreaded property. All right, let's see how we did. Actually, pretty good. Now, before we look at the substance of this question, you know, the little base here that receives your answers, I watch it as you're answering. And it's the second time now on a longer question where the first ones registering in weren't doing so great. The people who took a little bit more time to think the question through, those are the ones who are getting it right. So please do yourselves a huge favor. Do not rush through the questions, particularly this early on, because if you do, you're going to pick up some really bad habits and you're not going to be able to correct them. Take the time now. The more comfortable you get with the process, the faster you're going to be able to go anyway. So the key to the question is the statute. If you read the statute carefully, you knew what was going to be the right answer. So let's look at that statute. I'm going to tell you what to do with the statute. Those of you who had me for property, you've heard it before. But I tell you, it works. So you look for how many people are required to record under the statute. And by the way, you know, occasionally they might test a race statute. Really easy, so usually not. It's going to be a notice statute or a race notice statute. If just one person is required to record, it's going to be a notice statute, and that's your first person. If two are required to record, the first person and the subsequent person, it's a race notice statute. So how do we know how many people are required to record? Look for the verb record, any form of it. Record, recorded, records, any form of the verb. If you see it once, then you're likely to have a notice statute because it's saying just one person has to record, the first person, to give notice to the second person. If it says it twice, it's requiring two people to record, the first person and the subsequent person. It's a race notice statute. And this particular statute does say it twice. Recorded right there, and first duly recorded there. It's a race notice statute. If you read the statute carefully, let me point that out for you. So here we have it right here. That's time number 2. And right here, that's number 1. Now, many people will tell you, and not that it's a bad rule, but it's not the only rule I would follow, that you look for the first. Sometimes it doesn't say first. It says prior or other words, or doesn't even say first at all. So look for how many people have to record. And that's going to tell you whether you have a notice or a race notice statute. Now, if you have a notice statute, then you look for some, and you're going to be comparing two claimants. Who is subsequent? Who took later in time? Did that person pay value? Which for this exam is going to be an easy question, yes or no. And they'll tell you. And did that person take without notice? So subsequent, bona fide purchaser for value, without notice, actual, record, or inquiry. And then, if it is, as we have here, a race notice statute, who records first? Now, in this particular question, the key then is right up here. Vendee did not record. And we have a race notice statute. Vendee is the subsequent person, and he did not record. Since he didn't record, he loses, right? If your subsequent purchaser is not protected by the recording statute, that's Vendee in this case, what rule do we apply? Well, Yasmani's right. Shelter rule, if it's applicable, it's not in this case. But but you should always think about the shelter rule. It's true. But if there's no application of the shelter rule, what rule do you apply? First in time, first in right. And Yasmani mentions the shelter rule. Remember that if your subsequent person is not protected in his own right, look up his chain to see if a previous person in his chain would be protected under the recording statute. He can take shelter in that status. Also, remember that if your subsequent purchaser is not protected in his own right and the shelter rule doesn't apply and you apply that common law rule, it's just first in time, first in right. Your first person does not have to satisfy the recording statute. And there was a hand up. Who? Yes.
Can you refresh us on the shelter rule?
Yeah, shelter rule, once again, you don't start with it. You may take it into account, and I'd have to change the facts here. Suppose, though, and I'm not going to go back and rewrite all the facts, somebody earlier in Vendi's chain was a subsequent bona fide purchaser for value without notice who recorded first. Now, Vendi didn't record, so Vendi isn't protected in his own right, but that earlier person would have been. That earlier person doesn't need protection now because he doesn't own the property anymore. But he would have been protected. And because he would have been protected, Vendi can take shelter in his protected status and still win. Now, please make sure that you review recording and that you try out the techniques that I'm giving you here, because they do love to test recording on the MBE, and Florida loves to test recording on the essay portion of the exam. As you will see when you read your Florida distinctions, which I urge you to do earlier rather than later, Florida has a notice statute. They like to test recording. In essay form, ooh. So you're going to have to be able to write some of these principles. Use those 3 steps: subsequent, bona fide purchaser for value, without notice. Any other questions on number 10? Okay, number 11. Oops. Sorry about that. I'm looking for it to record your votes now. If you voted already, vote again. Sorry. Okay, anybody else on number 11? All right, good but not perfect. Privileges, of course, something that they will test with frequency on the MBE portion of the exam, and if they have an evidence component in Florida, which they often do, then privileges they will test in that component as well, because Florida has a different rule when it comes to these marital privileges. Key to this question, of course, is distinguishing between marital communications and spousal immunity, and what they cover and who owns the privilege. Make a little note on the side, Florida has marital communications with the same rules that apply under the federal rules of evidence. Of course, they don't actually have their own privileges, but Florida does not recognize spousal immunity, period. So just marital communications in Florida. Of course, this is an MBE question, so we're talking about the federal rules, and we recognize both marital communications and spousal immunity. Let's start with spousal immunity. Spousal immunity applies when and how. The parties have to be married when? At the time the testimony is elicited. And it covers any communication, including something that was made prior to the marriage, but who owns the privilege? The which spouse? Witness spouse owns the spousal immunity privilege. Who's on the stand here? The wife, the witness spouse. Can she waive the privilege? Yes, she can. Can the husband object? Nope, not for spousal immunity. But now we talk about marital communications. Marital communications applies, of course, to confidential communications made when? During the marriage. They have to be married, and the communication has to be confidential. Were they married when the husband made the statement here? And that statement, by the way, is a what? It's a what? Admission. You have to ask yourself these questions. It is an admission, which is what D says, but it's a privileged admission. So you've got to go in layers again and not focus on just one rule. It's an admission, but it's covered by marital communications. Who owns the marital communications privilege? Both spouses do. So even if the wife chooses to waive it, the husband can still raise it, which of course is why, if I can make it work, why A is the right answer. Okay, one last, I'm sorry, any questions about number 11? No? Okay, you can ask afterwards, Jaquetta. Okay, number 12.
Why wasn't the spousal one didn't apply, even though it covers all?
It covers it, but she waived it. It's only by the witness spouse. And so she waived it when she got on the stand.
So the question was,
Is can the husband object? And he can't object on that one because she's the one who owns the privilege,
right,
right?
yes, ma'am.
Yeah. So that's why. But A says it's marital communications because both own it, so he can object because he owns that privilege. He doesn't have standing to object to the other one.
Okay. I mean, I picked the right answers, but I just don't understand now that, because I was under Florida law, so I didn't think this applied anyway.
It doesn't under
But-
Florida law, yeah. But it
if
does.
It applies here, how come?
Because he can't object. Because she waived it as the person who owns it.
Objection to be stated, it wouldn't answer be no because, oh, okay, so this is just incorrect.
Yeah, it's incorrect.
And then no,
That
because
one's-
it's a must. That's okay.
They're
That would have
both
to be
wrong.
processed as elimination.
There you go. You have to be careful when you go yes or no, that the right answer is a yes or a no.
Okay,
Yeah,
thank you.
okay. Okay, let's see. Anybody else on number 12? And I want to see how many of you are sleeping. at this point? Interesting. Okay, I got to make sure I get the right number here. A is the right answer, and fewer of you were sleeping than I thought would be. Now, just let me comment first of all before we do the substance on this question. Actually, I have been very impressed as a whole. I don't say that lightly. You guys did a better job with these questions than most sets of students have done. Are you perfect? Not by a long shot, but I really, again, don't get a big head, but I'm very impressed by your performance today, so it's really good. Now, why did I say let's see if people are sleeping? Because it's actually a very easy question if you pay attention. It's a common law crime question. And if you had a professor who focused more on the model penal code, because that's what because all the books do, you need to go back and review the common law rules. The bar exam tends to be very heavy on common law crime and very light on model penal code crime. So you've got to learn those common law rules, including your levels of intent at common law. And this particular call of the question is attempted murder. At common law, attempt is what level? Specific intent. Did he intend to kill her? Nope. He intended to do all sorts of other things, but he didn't intend to kill her. And so A is the right answer. Many of you picked C. Why is C not right? Oh, it's reckless, right? And that could, if she had died, could C be the right answer? Absolutely. But she didn't die, and the call of the question is attempt, which is specific intent, which means you have to intend the consequence. That's the key to specific intent. Yes, sir?
If the person did that, would it be then C or?
Oh, it could be A or C. So
Or
that's,
just B with maybe saying victim because the victim died?
well, right. I'd have to completely rewrite the question if victim died. Let's put it that way, because the answer choices won't work. Right? Now, a couple of things. Hang on a second before you go out the door, because I always forget analytical answers to all the questions up here in front. And I have to draw. Now, what I'm going to do, and just hang on a couple of seconds because I know you're all eager to go. I had originally intended, thank you very much, had originally intended to talk some about essay writing, but I'm looking at the hour, and I'm guessing most of you would like to split at this point because you've been sitting for a long time. When I do my contracts property session in a few weeks, that'll be the first essay writing session we do. We can certainly cover all of the principles I intended to. If there is anyone, however, who is planning to write the Barbary essay for whenever it's due next week, Wednesday, I think, and you would like to spend a few minutes talking about essay writing, I'm happy to stick around. Before you go, and you see I'm mixing these up as many times as I can, I'm going to draw the attendance sheet. Yes, who's got the attendance sheet? Where is it? Send it back, and if you didn't sign, please sign. Let me pick one and see who we've got. Henry. Henry was back there. There's Henry. Okay. All right. Thank you very much. Now, next week, I would really encourage you to come to the session next week. It is Professor Kang. He's going to do his patented First Amendment lecture. And the good news on that one, just besides the fact that he does a really good job of teaching you the First Amendment, it's a fast session too. So you'll probably be out of here in less than 2 hours next week. Please do come for that session. Okay, that's it.